All right, Josh, if we can, let's start off with 643. Where we left off, we were talking. You reached out to Chief Judge Morrissey to get clarity as to what else it would cover apart from the.
Yeah, so I'll just I'll start. I'll read out what I received from the judiciary, which was from Chief Judge Morrissey. So the amendment was suggested because not all residential placements for drug treatment occur under 8507. In fact, drug courts simply order the individual to a particular placement in an inpatient residential facility. So per the criminal procedure article, custodial confinement includes inpatient drug or alcohol treatment. And a person in custodial confinement must be given credit for time served. So these kinds of orders were what the amendment was intended to include. So they did suggest adding some additional clarifying language, simply to say that these are placements in a inpatient residential treatment facility. So with the additional language that Chief Judge Morrissey was suggesting, the bill would read, starting at the top of page 2, absconding includes leaving an inpatient residential treatment facility that an individual was placed in under a court order for drug or alcohol treatment without the permission of the administrator as defined in Section 8101 of the Health General article. And just to be totally clear, the definition in 8101 of administrator is the program director or clinical director of an alcohol or drug abuse treatment facility or a healthcare facility.
Understand. So it's been seconded. It's the motion, but just want to keep it on. Just make sure everyone understands. I mean. So sorry, go ahead. Yeah.
The language is the.
Yes, that's the amendment.
Got it.
So everyone's good with the amendment.
Okay.
All right. Now the bill is before you as amended. So just can you provide the background again? So initially, when you guys went through the JRA, this was not supposed to have fallen under the revocation cap category. Can someone? Yeah.
Yeah. So what's happening is the revocation cap, I believe, is 15, 30, and 45. So the idea is if you're in the probation system and you have a technical violation, so like you get a dirty urine, you don't show up for an appointment. Those are the common ones. That instead of, there used to be no guidance whatsoever. And, basically you could get a hard-ass judge that would say, give him the whole 5 years back up. Or you would get ones that would do nothing. So you're trying to get a system of, you get a graduated sanctions. What we did not intend at the time was, okay, you get placed at a treatment facility, and you're there doing your basic sentence. You're not under the supervision, of a parole officer or probation officer, and you straight up just leave the facility. You abscond and leave. And the law right now has this weird, according to what the Maryland courts have said, I think it was the Special Court of Appeals looked at it and said, well, as long as you're still talking to your probation officer, you're not in violation, even though you just straight up left the facility. And so that's creating one problem. And the second one is, even if they can get them, the offenders are saying, I'll take the 15 days any day of the week over trying to do 3 months or whatever in this, or a month or 3 months or whatever in this treatment facility. So they're like, it's basically completely gutting the model of using the time over somebody's head to get them into treatment, which was the whole point of it. So what is happening and the end result of it is the idea of justice reinvestment was to move people from the criminal justice system into treatment, and this loophole is sort of is subverting that.
All right. No question, you can run this. And the two members that are providing testimony in the committee can vote when they get back, since it doesn't change the outcome of the bill. And is anyone any other unreadiness? Or go ahead, Senator Sidnor.
And just to make certain, so this bill is as amended, striking the 8507 language and just broadening it. Is that where we are?
Well, it's two, yes, because the judge, what Morrissey was saying, and if I have this wrong, Josh can differ, that judges sometimes through drug courts will order someone sent to a private facility, and they're concerned that if they do that, it will not be included in the law. So they want it covered so that basically if someone is sent in lieu of punishment to a private facility and they straight up leave, that it'll be covered as absconding under the law. And that doesn't mean a judge has to give all the backup time, but it just gives the judge flexibility back. Josh, do I have that about right?
Yeah, that's correct. So now, the word from the judiciary was that oftentimes drug courts don't use 8507, they use alternative dispositions to essentially accomplish the same thing of sending someone to a treatment facility. So this would simply broaden the bill to include all of those situations, and they suggested this additional language to make it clear that you're talking about court orders to place someone in drug or alcohol treatment.
I mean, just to assuage concerns too, I mean, this is like my whole law that I put in, this technical violations. This is my big thing. So I would not put in something to gladly gut it or hurt it. To me, they brought this up numerous years, and it makes sense.
Okay. Let's do this. Let's move on to Senator Wallstreicher. Do you want to move on to that, or actually, yeah, because I know that Senator Hedelman wants to be on Senate Bill 834, and she probably wants to vote for it. So let's go on to Senator Wallstreicher. The two.
Yeah, so this is actually two bills together because one is the constitutional amendment. So this bill and the constitutional amendment bill prohibit a party in a civil action from requesting a jury trial if the amount in controversy does not exceed $30,000, exclusive of attorney fees, if an attorney fee is recoverable by law or contract. So currently, the District Court of Maryland has exclusive original jurisdiction for a civil case in which the amount in controversy does not exceed $5,000. And then the Circuit Court has exclusive jurisdiction for a civil case in which the amount in controversy exceeds $30,000. So if it's between $5,000 and $30,000, a plaintiff can file in either court. But if a plaintiff files in district court, either party can demand a jury trial. And if that happens, the case is then moved to the Circuit Court. So this would just stop that. Yeah. And there are two amendments in your packet. So these amendments were submitted by Senator West. So it decreases from $30,000 in the bill to $20,000. If Senator West, did you want to put those amendments in, Senator West? Or?
The answer is not right now.
Not right now. Okay, so then there are no amendments.
I've already shared with Senator Wallstreicher and Senator Smith that I've been approached by people who have told me that they could provide me by early next week with information/documentation that if we were to pass these bills, automobile insurance premiums would go up. And I haven't seen that information. I'm a little surprised, frankly, it hasn't been provided before this, but it does seem to me it's worth waiting for the weekend in order to give them the chance to provide that information if it exists. So I would request that both these bills be held until our next voting session next week.
So thank you, Senator West. You know, I'm reluctant to hold the bill, not because of the good intentions of the requester. I think he's well intentioned. This is the third year that this bill has been in. If the insurance industry believed that this would raise premiums, you would be sure to know of it because they would have offered it as part of both their oral and written testimony in each of the last 3 years. And that hasn't occurred. And so I also have knowledge that the the House Chair has similarly requested this information, and no such information has been provided to him. So I'm happy to accept the hold and wait until next Tuesday as a favor to my friend, Senator West. But I don't think we're going to be provided what is being looked for here.
Yes, I really appreciate your willingness to wait until, I guess, next Tuesday. We'll have the next voting session. I will promise you, if this information does not materialize by next Tuesday, I will probably vote in favor of the bill. But it seems to me it's worth giving them the weekend to provide the information if it exists. Thanks.
Okay, excellent. We'll hold till Tuesday and look for the information. All right. So now let's go just to the final bill of the day, 834. Heather, so we've got another. We already adopted the previous amendment, so if you could just do we adopt the other amendments? Did we already adopt those?
No, we adopted amendments on.
No.
All right, you're right. We didn't. Okay. Well, I guess, can you explain the amendment packet, and then we'll, since it's now different.
Yeah, so I emailed the committee an amendment right before we started voting. So it's very similar to the amendment that we were discussing prior to your floor session. The difference is in this amendment, and so the amendment number should be 618179 is just a reprint. So it completely strikes the oral, written, or physical language, and then the previous amendment it was verbal, nonverbal, just because it just goes with conduct to keep it simple. And then under the definition of harassment on page 2 of the bill, it refers to it as unwelcome or offensive conduct instead of just conduct. And that language was pulled from the EEOC website. And those are the changes.
I'm just going to make a motion just to adopt these amendments so we can work off of this. Is everyone okay? All right, great. And then she has an or there.
And
Senator Kessley.
yes,
So, looking on the amendment now, page 2,
yes.
line 25 and 26. Okay, and it says that the conduct, this is talking about offensive conduct, based upon the totality of circumstances, the conduct, and it says alters an individual's terms, conditions, or privileges of employment. I'm just trying to understand that. I mean, talking harassment and offensive conduct, and then we switch into it alters the terms, conditions, or privileges of employment. Where does that language come from? It just seems like an odd fit.
That was the language that was proposed for the advocates because they were unsatisfied with the interfering with an individual's work performance. They thought maybe if the harassment wasn't directly tied to like an evaluation of like a work performance of the individual, it might be too limiting. So they thought the terms, conditions, or privileges was more expansive.
Also,
I mean,
because some
so I'm
people,
surprised we would want it.
some
I don't know
people
why
would-
you mentioned it has to interfere with their work performance.
the rationale is also that, yes, if you were still a high performer, it doesn't mean that you weren't.
If I'm a high
subject-
performer, I'm not being impacted at all. I mean, it shouldn't depend on whether I'm a high performer or a low performer. Nobody should endure harassment, so I'm not
I think
sure.
that's right.
I'm not sure why it has to affect my conditions of employment. I mean, I'll grant you that there's probably an implicit, no matter what your employment contract says, there's probably we could have an implicit statement, I'm sure the court would read in there that says, and you can't use, offensive language to me or racial bias, but that's what we're talking about here. So I'm just not, I mean, I think this amendment is a big improvement. I just find that language kind of like, what? Where are we going with this?
Are you saying that
You
you would
could
prefer
st-
to read based on the totality of the circumstances, the conduct unreasonably creates a working environment that is reasonably perceived by the victim to be
Yeah.
abusive or hostile?
That's fine
Yeah,
by
wouldn't
me.
that be more appropriate?
That's fine by me.
And I just don't know what we get by the other thing, because then you're saying it has to interfere with,
So you're taking out submission and conduct as a condition of employment? Is that what
Part
you're
that
doing?
says alters, is it on page 20, page 2, line 25? I would take out the section on the amendment.
Sorry, that should be in
It
here.
says
I had it right
alters,
away, but not here.
you look at alters an individual's terms, conditions, or privileges of employment,
That's fine,
including.
but that's fine by me if you want to strike that.
Okay, sure.
I don't, to me, it just confuses the issue, what we're talking about. It creates a hostile environment that is reasonably perceived by the victim to be abusive and hostile. So, and I guess my real question comes back up to the top. As I mentioned, to you, the old language, it says, from EEOC was excluding petty slights, annoyances, or isolated incidents. So I guess that language is somewhat in here because we say that's reasonably perceived. It wouldn't be reasonable, I guess we could say, to perceive petty slights and annoyances as abusive or hostile, right? So
That's already in the statute too, by the way. That's in our statute. That's current. That's somewhere. That's language that's borrowed from another part. I've seen that in our statute before.
Case law.
The petty slights. We already strike, but this bill strikes that out.
No, I know that. I'm just trying to figure, because I thought the petty, the one reason I like the petty stuff was, I don't like petty stuff. One reason I like the language was because
Yeah,
our
yeah.
discussions earlier that workplaces, it's a workplace, and people are, of both sexes, are frequently a little bit racy, and they shouldn't be, but they are, and we don't want to take everything to the EEOC on all that stuff.
So, you know, the reasonably perceived thing, like you said before.
Well, that's what I'm looking at, that's reasonably perceived, maybe. See, but then if you say reasonably perceived by the victim, then you'd say, wouldn't that say, the victim would come in and say, well, it's reasonable that I perceive that, because you know what? I was a rape victim, and pretty much anything you say about women is really offensive to me. And so I don't want to even, you know, something like that, or, you know, victim of incest or something. So pretty much everything is offensive to me.
That's what that was the issue with this one.
I think that's right. I think, yes. Can you explain that? Because
Yeah, so Senator Castley, I think what you're talking about, that was the issue with the lines 28 through 30, which were struck because that was a reasonable victim of discrimination, which was causing issue. But the way it's worded in line...
that was the MCCR's critique, part of it.
Yeah,
And this is the language that they came up with to fix that.
Yeah, to make it reasonably perceived by the victim. It can't be unreasonably perceived.
That you struck there.
Yeah, they did not like that.
Yeah, but now this gets us right back to the eggshell plaintiff that's reasonably perceived by the victim. Because what you're really saying is it's not reasonably perceived by a normal person. It's if the victim is very hypersensitive, then that's the standard. It's not an objective standard at all.
So do you want to maybe take out by the victim?
I mean, how do I say what the victim?
So are you saying that you'd like to strike, so creates a working environment that is reasonably
strike by
perceived
the
to
victim.
be abusive or hostile?
I would strike by the victim, reasonably
victim.
perceived to be.
You could put that a reasonable person.
That a reasonable person would
EEOC
perceive.
uses reasonable person standard.
So that
EEOC does.
Correct.
so that a reasonable person would perceive.
I mean, you could have that it was actually seen by the victim, but I'm not sure, how do you, you can't prove, it's a worthless standard, because how do I ever establish what they actually perceive? It's what they reasonably perceive. Yeah.
So just can you read it back one more time and then add the end language as well?
Can I just talk through it once, real quick? So the way it's laid out now then is, we define harassment as offenses, unwelcome or offensive conduct. And then we say, for this,
It should be and instead of or.
and.
Unwelcome and offensive.
Okay. And then on top of that, it's based upon, it's conduct that is based on one of these immutable characteristics. So if you get those two, offensive and unwelcome conduct based upon an immutable characteristic, and either one of three things, that you are forced to endure that as a term or condition of employment, which means it had to be more than just one time. I'm enduring it, so it's going to be something that I'm having to endure every day for some period of time, so I endured it. Okay. Or number two, it was use as a basis for an employment decision. So I had to be that in order to get there, or I'm sorry, I was that so I didn't get hired, or I didn't get the promotion, right? I was a woman, person of color, whatever, so I didn't get, I guess that's really where number 2 is coming in. And then number 3 is our third option, which delete, forget 1 and 2. It says that based on the totality of the circumstances, the conduct creating hostile, it creates a hostile work environment that a reasonable person would see as abusive or hostile. Okay? Are we going with abusive and hostile again down there? I'm sorry.
So the way I have it is based on the totality of the circumstances, the conduct unreasonably creates a working environment that a reasonable person would perceive to be abusive or hostile.
Okay, and that's or abusive or hostile?
Yes, abusive or hostile.
Okay, all right.
Okay, so then just everyone, I agree with what we've come up with here. So just to be clear then, with the amendment we've already adopted, on lines 12, you're just adding unwelcome and. On lines 25, you're striking alters an individual's terms, conditions. It says line 25, yeah, terms, conditions, or privileges of employment include, yes, so striking that. Creating a working environment that, what is it, a reasonable person would perceive to be abusive or hostile. Okay, great.
We're making the same changes under K for sexual harassment.
Yeah, I could.
Right? And the lower part of sexual harassment will make those same changes?
So with K, you wouldn't want to add the unwelcome or offensive because it already has the consists of unwelcome sexual advances, requests
Okay,
for sexual
already
behavior.
there.
It
But-
kind of already has that.
But on lines 12 and 12, you would,
But we strike alters their terms of conditions of employment, right?
Yeah, so I would alter, that would be line 11 through 14. I would,
Right, but then and then
Reflect
just
that.
continue with the rest of it. That a reasonable perceived by the victim to be. Then we would change the reasonable perceived to the same language as on the previous
Yeah.
one. Okay?
and then I'd also make the same like
Okay.
written, verbal, nonverbal.
I like that.
changes.
Okay.
I think that makes it better. All right, is everyone okay with adopting those amendments? All right, let me just catch Senator Hellman up to speed real quick, 2 seconds. All right, so now Senator Hellman's caught up. Bill's before you as amended. I know that Senator Hellman and Senator Lee wanted to be amended on. Senator Jackson's on. Senator Sidnor and Senator Waldstreicher. All right. So everyone cool. Does we need a roll call or is everyone okay? Waldstreicher, Hedelman, Sidnor, and Jackson. Is everyone okay with adding those? All right. Is everyone okay? Motion's for favorable. Second. Everyone's okay? Excellent. Okay, so we're probably we have a lighter schedule next week, hearing-wise, which will enable us to vote. So look to vote, what?
So we don't have any bills on Thursday. So you had mentioned voting on Tuesday, so I don't know if you know what you want to vote on Tuesday, or if you just want to, it's up to you.
Well, we'll kick out a list on Monday afternoon, but, so we can vote on Tuesday, and we have no bill hearings on Thursday, so we can vote on Thursday and Friday. So,
we have one bill hearing on the 16th so far.
what day is the 16th?
It's a Tuesday. But
Next
that's
Tuesday.
Courtesy report out.
Got it. So we can vote 3 times next week, and I think that, how many bills do we have, like the longest day we have tomorrow? Next
We
week?
have 7 bills on
Next week.
Tuesday,
Okay.
and then I think we have 9 bills on Wednesday.
Okay. All right, so look, Tuesday, Thursday, Friday voting, otherwise just bill hearings. That's it. Excellent. Have a good weekend. See you later. Oh, wait. Hold on.
Oh,
Floor leaders.
Yeah.
Floor leaders.
So,
Can you read off and just see who you want?
all right, so this is not in order because this is just coming off of the committee report, but Senate Bill 15, Senator Bailey's firearms.
He's got that.
So Bailey. Senate Bill 190 is Huff's use of medical cannabis. Senate Bill 270, Senator Waldstreicher. This is the indecent exposure bill that we voted out a while ago. Senator Castley, Senate Bill 385, organized retail theft. Then we have Senate Bill 61, public buildings changing facilities. Senator Lee.
Carol, we'll catch you up.
Senate Bill 613, Carroll County Sheriff salary.
Who wants a Carroll County Sheriff's salary?
Jackson. And then we've got Senate Bill 114, Senator McCrae, criminal procedure, expungement of conviction, driving while privilege is canceled, suspended, refused, or revoked.
Who wants that?
Carter. Senate Bill 140, Senator Peters. This is the commercial motor carrier safety inspection and performance and insurance information. West. Senate Bill 263 is a Senator West bill, corporations and that's West. 293, Waldstreicher's injury or death of a vulnerable individual.
He's got it.
And then Senate Bill 501, towing or removal of vehicles from parking lots, placement of signs.
I can do that.
Sidnor, you want? Is that good? Is that you wanted that because you're.
No, well, I just got invested in it because I'm gonna brought my.
If you're invested in the sign towing, give it to Jeff.
Oh, you got it.
Who's got it? Waldstreicher. And then the 2 that we just did, so Senator Huff's bill and Senator Smith's bill, you guys each want your own bill?
Yeah, I can do one.
Yeah.
Okay.
Did you do the Carroll County Sheriff's?
Yeah, Jackson's got it.
That's fine. I don't care.
Okay. That's it.
Give your fellow sheriffs a raise. That's fine.
Cool.
All right. Senator Carter and Senator Hunterman, I need to just get your votes on the one when you guys were voting.
That was Huff's bill.